Donovan, if you need water, there's some, I think, water in the water, the picture behind you, maybe your co-counsel could. Good morning, Mr. Donovan.
Morning, Your Honor. And may it please the Court, my name is John Donovan, and I represent Genzyme Corporation and the directors that have been named as defendants in this action. The question that this case presents is the degree to which external influences affect the ability of directors of a corporation to exercise the power to modify the capital structure of a corporation pursuant to the provisions of its articles of incorporation. The plaintiff and the appeals court attempted to invoke two different sources of that obligation. In the first case, they attempted to use the implied covenant of fair dealing as the basis to say that there was a limitation or a modification or a limit to what directors are able to do under the Articles of Organization of Genzyme, in this case to eliminate two different classes of tracking stock. In this case, the only thing that is issued is the so-called biosurgery division tracking stock. The question is, to what extent does the implied covenant affect the ability of directors explicitly to do that? It is clear that the power exists. The Articles of Organization clearly say that at any time the directors may perform the optional exchange and exchange outstanding shares of tracking stock for either cash or a defined number of shares of general stock, Genzyme general stock. And the amount by which the directors are limited is, again, set forth in the articles. They may do this, quote, at any time, and they must do it at an average of closing prices of the stock over a period of time. The plaintiff complains that, serendipitously, that because the period that was chosen included a period of time when the price happened to be rising, that the result was unfair. Well, the question is, how do you shoehorn that into the implied covenant? Well, I suggest to you two things. First of all, the mere fact that stock prices are rising happens. And if the calculated ratio is, by definition, an average, arithmetic will tell you that if the price keeps on rising, the average will be something lower than the final price.
The formula seems very complicated to me. I don't know. Is this a typical way the formulas are worked out for share purchases?
Your Honor, I can't say that anything is typical in this case because tracking stock is so rare. Okay. We have tracking stock in very few organizations. There are very few public companies.
No, but the way the purchase prices are worked out is common. It doesn't matter really whether it's tracking stock or not.
In public companies, it is common for redemption provisions. I think probably the most common analogy would be to a redeemable preferred stock, is to use a market price and to use an average over a period of time. This corporation chose that for a couple of reasons. One, it's discernible. You know what it is. You can always tell it. It's not subject to some subjective issue. And second, the timing period is reliable. It is over some extended period of time. And the charter describes exactly how you do that. You pick your day upon which to act. And boards, typically set the time at which they'll have meetings long in advance. In this case, they decided in February they would consider the issue in May. That didn't predispose it. It just said, we'll decide it then. Of course, once you decide, you must act. The charter says you go back 30 business days and calculate forward 20 business days of average pricing. That's how it happened. And that, I would say, is not atypical, Your Honor, because tracking stock is so rare it's hard to see.
Mr. Donovan, it seems, and maybe I should direct this more to Mr. Schubert, but it seems to me that under the articles, it wouldn't matter what was happening to the price.
Precisely, Your Honor. The articles are designed to avoid those issues.
Or put it this way, who knows what is going to affect the price? They can point to an action, and it's arguable. It's not arguable. Let's assume that it's established that the action and or whatever it was, the licensing or whatever the event was that caused the stock to jump. I forget what it was.
It was just to disclose your second quarter results.
Whatever it is.
Right.
It could go up that day, down again, because who knows? But let's assume that there's something that the board knows that is going to make this stock far more valuable, I'm still left in the position of saying, but that was all spelled out at the beginning, in a sense, before anybody knew what was going to affect the stock.
You're right, Your Honor. A couple of things. First of all, directors can't tell what will influence stock prices. The market moves in ways that certainly I can't predict. If I could tell what would happen, I wouldn't be standing here. Secondly, they should not be exposed to some liability because of subjective valuation changes in the market. And that's why the charter was written the way it was.
Let me ask you differently. Let's say, for example, that these directors really wanted to invoke this provision when the price was depressed, for whatever reasons, good judgment reasons. They thought that would work best for Genzyme. And it looks as though, the market's going to go up. And then it turns out post hoc that the market kept going up and up and up and up and up and up. So in fact, by taking the decision at the May meeting, was the lowest that they could have been within the normal regular schedule. I still don't see why that's a breach of an implied.
Well, neither do I, Your Honor. And Judge Van Gestel didn't, and the way the appeals court got to it was by an analysis that, to me, doesn't make any sense. If you say that the implied covenant means what stockholders could legitimately expect, they could not expect anything other than that it could happen by the articles at any time. On what basis would they have to think, no, they must do it at some other time that I think is fair, or when the market happens to be high?
To what extent does the claim that there were representations, and I'm not sure how this goes to the implied covenant, that there were, quote, representations that these shares would appreciate greatly, quote, but only over a long period of time?
Well, first of all, there's nothing like that.
Okay.
Second of all, it's not in the complaint. And third, it would make no difference, because the power of the directors is not limited by what someone says they think the value is going to be. It is limited by what is in the articles or what the implied covenant does to the articles. What does the implied covenant say? We constantly say in our cases that it is designed to avoid taking away an expected right to deprive some party from the fruits of a contract. Well, what's their expectation here? Their expectation here is only that at any time they could be subject to that. Well, what else animates the implied covenant? I'd suggest to you that your cases say it is circumstances where someone takes advantage of a contract provision or otherwise to get something that they're not entitled to get some benefit, to get something unusual at the expense of the other party, whether that's Fortune taking the commissions away or Uno, the right to bid on the condo unit. Well, what did anyone get here? There you do have to understand tracking stock a little bit, because tracking stock is entirely notional. When Genzyme exercises this, and the plaintiff's entire complaint is crafted to suggest that somehow they bought something at a low price, they didn't. They did not acquire anything. The only thing that happens upon the exercise of the redemption provision is that biosurgery stock is exchanged for a number of shares of Genzyme General stock, but nothing else happens to the corporation. They don't buy any assets. They don't buy any rights. They don't incur any more liabilities. The equity is the same.
Well, what could the company do after it purchased the tracking stock or after it redeemed the tracking stock that it couldn't do before?
Only use its equity as currency in different ways. The reason that companies create tracking stock, Your Honor, and in this case in particular, is to have a device to, it was thought at the time, put a capital silo, if you will, over a certain element of the business. In this case, a product that was called Synvisc. They did the same thing with a molecular oncology product designed to use tracking stock as the currency to raise capital to develop a pharmaceutical. Well, it turns out it didn't work, as the complaint will show you. The stock price went from $11 and change down to $1.14, which is why the directors acted. People weren't getting the benefit of this like they thought they would. The market didn't, in fact, honor it. And they couldn't then use it as currency, for example, for additional acquisitions in that space, or use it to raise more capital for that very business.
I'm trying to understand a little bit about the plaintiff's complaint, but aren't they saying something along the lines that It's the manner in which the exchange took place, and that the directors knew that the first quarter profits for 2003 were substantially higher than those of the previous year, and that other decisions involving the corporation's market in France for that particular product had changed, so that the directors knew that the market was sort of bottoming out for that particular stock and it was undergoing a turnaround, and they exercised the option to make the exchange just at the right time, with some pretty sophisticated knowledge that the curve was turning. Is that the essence of their complaint?
I think the essence of it is that the timing was somehow bad, with the knowledge that something might happen. I suggest to you it gets to Chief Justice Marshall's question.
But if that's true, and on a motion to dismiss, if that's true, if they in fact could show that, does that open the door for them, or doesn't it open the door for them for a breach of the covenant of good faith?
I think it doesn't for a couple of reasons. First of all, what animates the covenant? And the first is obtaining something that you could not otherwise get. That in this case. Second, is it somehow depriving the plaintiff of an expectation? A plaintiff, in this case, could never have an expectation other than that he would be subject to that exchange. The third piece is the way the appeals court went in it.
But that's true if Genzyme perhaps didn't have certain specialized knowledge which was informing this decision. And what the plaintiffs are saying is they had a particular knowledge that allowed them to make a decision that would essentially knowingly minimize the value of their stock at that point in time.
Well, minimize the value, again, you have to break that down. Minimize for what purpose? For the purpose of exchanging it? But assume the opposite, Your Honor. Assume that instead...
Didn't they buy something?
No, they didn't buy anything. They exchanged one equity security for a different one. Take it a different way and consider the implied covenant.
No. I mean, when they bought it at $11 a share. They
issued it at $11 a share.
What did they pay for it?
Let me back up. The stock was created upon the merger, the acquisition by Genzyme Corporation of something called Biomatrix. And the stockholders of Biomatrix and other holders of a different tracking stock of Genzyme exchanged their shares of Biomatrix and what was called tissue repair, surgical tissue repair, for this stock. It had a value in the marketplace when that happened. The market valued it at $11. But Genzyme didn't issue anything, didn't get $11 back. That didn't happen. But keep on breaking down your hypothesis and take it into Chief Justice Marshall's question. If the directors have this specialized knowledge, what does it mean? What does that mean for them? Do they know that that means the price will inevitably go up? Can't tell. Consider the opposite one. Consider instead that the price, instead of being inevitably going up, was inevitably going down. Let's say they knew that, and the price was instead going from 11 to 1. Well, on that arithmetic, you would say that by definition, the formula would yield a price that was higher than the last price. Whose ox would that gore? It would mean that the ratio was higher, but Genzyme General stockholders would be subject to more dilution, if you will.
But would they vote to take back the stock at that point?
Oh, absolutely they could, Your Honor.
I mean, I know they could, but would they?
And why wouldn't you? If, in fact, the price was inevitably sinking to nothing and the utility of the security in your capital structure was diminishing to nothing, then almost by definition you would be obliged to do it to protect the interests of your stockholders. The appeals court came out the same way. They said, well, what if they know this? Well, there's nothing in the implied covenant that we can really find that animates this. There's no bad faith. The timing we know from the charter, no expectation could exist, and there's no benefit arising. Instead, we think something in their fiduciary duty overlays the implied covenant, and that is the trigger for implication of the implied covenant. Well, that's kind of a strange result when they said separately that there was no sufficient allegation of a breach of fiduciary duty here. Stated differently, what the appeals court said was, in the absence of a breach of fiduciary duty, we will find that the existence of fiduciary duties implicates the implied covenant, that it is triggered by something that, by definition, they have said does not exist. Well, what could possibly trigger the implied covenant? I've tried to think of that because it seems to me it's a fair question for you to ask. How would we instruct a jury to think about this question? How would you say what the implied covenant is and does? How would I, as a counselor to directors, tell them they could or they could not exercise the existing power of the articles? I suggest to you that there is nothing different in that analysis than what already exists under regular breach of fiduciary duty law or, with respect to disclosures, the federal securities laws. Stated differently, the implied covenant cannot be determined to be broader than the pre-existing obligations that exist under fiduciary duty principles or federal securities laws.
Or if there is a reasonable expectation. That's the weakest part and it seems to me that there's no reasonable expectation in this case that these plaintiffs could require this action by the Board of Directors when the stock was going to go up, even on, quote, inside information, and I'm not using that in a legal sense, or go down.
And indeed, Your Honor, in the very prospectus that was issued to these people upon the adoption of this security, they were specifically told, and it's in the appendix to the briefs, the directors may exercise this power at a time that may be disadvantageous to you. They were explicitly informed of that expectation you're talking about, Your Honor. And with that in mind, how could they believe they would only be subject to the risk at a time?
It's not a belief.
Purposefully disadvantageous, could it?
Well, if it were purposely disadvantageous, then it would be either a violation of federal securities laws or a breach of fiduciary duty, but wouldn't trip the implied covenant.
It's not.
And we don't have allegations that do trip the fiduciary duty principles.
My last comment, which is really to give Mr. Schubert a head start, is it's not a belief. It's a reasonable expectation.
That's the language of your cases.
Yes, and case. Thank you, Mr. Donovan. Mr. Schubert, you know what my questions are.
Robert Schubert for the plaintiff. May it please the Court. Let me clarify first what the heart of this case is. It is a claim by the plaintiff who owned tracking stock in biosurgery, in Genzyme biosurgery, against the corporation. And it is a breach of contract claim.
But why, if the articles of organization have this formula in them, you got the stock knowing that that was the formula, and I suppose somebody who's better at math than I am could sit down and figure out that I may lose money if this formula was applied when the stock is going up. So your clients knew that.
Thank you, Your Honor.
Where's a breach of any?
If I might direct the Court to page 12 of my brief. What I usually do when I make this argument, I made it in the Superior Court and the Court of Appeals, I usually bring a big chart which shows the price action of the stock and the announcements on various dates. And I was advised that might be not the best device here today, given the layout of this courtroom. But my whole case is on page 12 of my brief. And I know, Justice Cowan, you asked a question regarding how the formula is calculated. If you could turn to page 12. First, let me go through how the formula is calculated. The formula is this. Under the Articles of Incorporation, Genzyme had the power to announce an exchange to take out or redeem for cash or stock the biosurgery stock. And when they made that announcement, they could do it according to the articles at any time. You would look back 30 trading days. And if you look at the chart here, there's a valuation period. The takeover is announced May 8th. You can see the little arrow, exchange announced. That triggers, under the articles, a 30-day period going backwards, 30 trading days actually, 30 business days. And you'll see that bracketed area. And what the shareholders are entitled to under the articles, the literal terms, is 30% more than the average of the next 20 days. So it's a backward look. And that is absolutely crucial, Your Honors. Absolutely crucial. Because this is not a situation, as defendants would have you believe, where there's just a risk. We announce that we don't know what will happen. This was announced at a time when the corporation knew exactly what the number would be produced.
But couldn't your client have figured that out mathematically ahead of time?
I'm sorry.
Couldn't that have been figured out mathematically ahead of time by just taking different numbers and working this out?
When the exchange was announced,
No, way ahead of time. You don't need...
because...
You don't know the number, but you know that you certainly know that the buffer of the 30% increase may or may not be big enough. If the price is going up and it goes up more than 30% of that average, you'll be getting less than the precise current fair market value. Now, of course, if the average has occurred and it's only gone up 20%, getting that 30% is going to get you more.
Well, I think the
I
ultimate
mean,
question...
people bought
I'm
into
sorry.
that buffer as a rough measurement to deal with that problem, knowing that it could go either way. It could hurt either or help either side.
I respectfully submit that what they did not buy into was that the corporation would pick dates knowing they would create a valuation period that did not reflect publicly available information in the market. It's a well-known concept accepted by the U.S. Supreme Court and by economists that the market basically absorbs and reflects in the price of the stock all currently available information.
But if what you say is true, then if they had waited 2 weeks, you wouldn't be here.
15 trading days, I wouldn't be here.
Or what if they...
Exactly.
What about a month earlier? You wouldn't be here.
That is correct.
If it was on the way down.
What we have is opportunistic timing. This is not picking a date.
But couldn't you realize that? I'm sure accountants or people, actuaries, people like that, could figure this out, that this could have happened.
Well, this could happen, but what the individual shareholders did not assume the risk is that the directors, or more correctly the corporation, because it's a contract with the corporation, not the directors, would game the system.
They're not gaming the system. They are complying with what the articles of and I'm not. It's what's your reasonable expectation. Your reasonable expectation is they tell you what they're going to do. I can essentially parrot back to you. Often directors have, I'm going to call it confidential information because I don't want it to be insider information in the way that term is usually mean. They have confidential information, and they have to make a variety of judgments, and the market responds to information, and maybe the stock is going up and going up and going up and going up. But what difference does that make?
The difference is the reasonable expectation, we believe, of the shareholders. And it says, and Mr. Donovan has pointed to some language in the public pronouncements of the corporation. And one of the public pronouncements, and I'll read it, it's in our appendix.
In relation to when?
That upon the exchange, a Genzyme General stock, there will be a 30% premium over the market value of the exchange shares. What I'm saying is,
But didn't he also say that in the prospectus there was a disclaimer that this may work to your disadvantage?
Sure. Yes, but the risk that was not assumed is that a corporation would manipulate the timing of the transaction, and we're at the complaint stage.
It's not manipulating the timing of the transaction if it can do it at any time. You can do it at any time, provided that, for example, where's your page 12? And I'm not going to add the days. Provided that the valuation period shall never be deemed to be operative if in the subsequent 15 days there is you can do it all kinds of ways.
Your Honor, but the same argument was made in the leading case on the implied covenant of good faith and fair dealing from this court.
Which
the
one?
Fortune versus NCR.
But Fortune was different because Fortune, as you
Your Honor,
you well know, Fortune it was, I agreed that if you had two different, they weren't contractual terms, but I agreed that if you complete the sale, you will get X.
No, Your Honor. The contract said at any time the salesman could be terminated, and the court, the SJC, said in its opinion that salesman got every penny he was entitled to under the contract. That contract permitted his termination at any time. What it did not permit, because there was an additional provision which the trial judge ignored, an implied covenant of good faith and fair dealing, it did not permit an unexpected, bizarre result.
There was a very reasonable expectation in light of the fact that sales occur here, and we all know, if you've got any friends who are salesmen, they think the deal is done when the sale occurs. We think the deal is done when the money comes in. And what happened in Fortune, as I remember it, is the sale occurred, he was terminated, and then the money came in, and of course you don't pay out your salesman until the money comes in, but the reasonable expectation was that he would not when he would be, he could be terminated any day. Nobody complained.
Your Honor, I would say that when a stock price is, when the stock is $2.50 a share,
Right,
which it was, according to the chart,
right.
and when the shareholders have been advised in public pronouncements to the corporation, they will get fair market value plus 30%. They don't expect to get $1.77.
If I may say so.
And this was known.
Mr. Schubert, if I
Yes.
may say, then go to the Securities and Exchange Commission and say, this is a misrepresentation to the public. That's what that claim sounds like to me.
Well, Your Honor,
In other words, you were promising me something, and you didn't do that the prospectus is misleading.
This is a case of breach of contract, Your Honor. And I might say this, that if the Court has a question, what indeed was the reasonable expectation? Was this gamed? Did the corporation game it and intentionally destroy this value? These are factual questions. It's a breach of contract case where all we need is notice pleading. These are matters of fact. We were never entitled to get into the records of the corporation. We never got into discovery because it was viewed that there was an absolute right to do this at any time. But this Court and the appeals courts have repeatedly held that any time is often interpreted as a reasonable time.
I take it that you're, as you suggested, if this had occurred 15 days later, you would not be on your theory.
Yes, Your Honor.
Because even if the price was going through the roof and the company said, we got to get this stuff exchanged now before it goes back to $11 a share, although maybe for capital purposes they might want to not have been happy with it going to $11 a share. I don't know what all the external and internal dynamics of this kind of stock is. But so even if they were to do it 15 days later and cut off a stock that was really moving up, you would say we couldn't be here, and that's not – the stockholder doesn't have a reasonable expectation of making a certain amount of money. That's right?
Yeah,
That's
all
not
I'm
the
saying
reasonable
is-
expectation.
all I'm
the reasonable
yes.
expectation I think you're focusing on is that the fair market value will indeed be a fair market value, and the timing period selected here in retrospect ensured that a major portion of that timing period would be during a time when the market didn't know what the value of the stock was because they didn't have the information. Is that
Exactly,
the
Your
basic
Honor. And it didn't have the public report,
public report?
which showed sales over 20%. When the stock got that report, it went up 20% in one day and kept going up and up and up. All I'm asking is for a chance to prove at the trial court level that the shareholders are entitled to have a price determined by all the public available information on the market. Now,
But that's
you're gonna blow up
not
the
the
formula.
reasonable expectation. That is not the reasonable expectation. It cannot be the reasonable expectation. I mean, that's-
well, I think to the contrary, the reasonable expectation is not to have a provision which indicates a premium, have that premium destroyed when the corporation knows, when it picks May 8th, it knows it has picked a very, very disadvantageous valuation period based on publicly available information. Let me contrast what the appeals court did and what the Superior Court did. The appeals court looked at Fortune. It looked at Anthony's Pier 4, where there were absolute rights to withhold approval of a development contract, but absolute rights gave way to the justified expectations that someone would not produce an unfair result. The Superior Court said there can be no breach of the implied covenant unless the contract has been breached. Another provision of the contract has been breached. I submit that totally misinterprets the implied covenant as interpreted by this Court and under the restatement of contracts. And the Court said as long as there's literal compliance with the contract, you can't breach the implied covenant. That goes directly against Fortune. It goes directly against...
Well, I read Judge Van Gestel a little differently, and maybe he was overstating it. But he really takes issue, and I think it underlies my concern, is that there's no manipulation. You know, he says manipulation, that the directors, there's no proof that they manipulated the market. I don't think he's really talking about the market. He's talking about the value of your client's shares. You know, you're saying if you're going to make this announcement, they must have known that it would go up, and in fact it went up.
It's not that they knew it had already gone up based on publicly available information, and they intentionally picked a period in which there were only 5 days where the market knew the good news and 15 days where It had no knowledge of the bad news. They picked that period. It's like options backdating. They picked the period knowing the result.
No, it is not like options
well,
backdating. It is really
it's not exactly
like
it, but they picked a period knowing it would destroy shareholder value. They knew it as a certainty. They could get out a calculator, as Justice Cohen has suggested, and figure this out. They knew that the $2.50 a share and much of that value would be destroyed the moment they announced it, because they didn't wait the 15 days, because they were not allowing the market. They were not allowing a valuation period which absorbed all the relevant market information. As a certainty, they destroyed shareholder value. And these are small shareholders.
Well, why do you say you're sort of presuming what happened for a month afterwards?
No,
too.
I'm not.
Because if it on May 8th the stock had gone down, if it had plummeted at that point, you would be wringing your hands delighted that they had picked May 8th as the date.
The market, they would have gotten what they'd entitled to the market. They would have had a price determined by all the information out on the market. That's all we asked. Let me speak to a somewhat different...
All the information that was on the market, as of what date?
All I'm asking is when you pick the date and you go through the formula, you look back 30 days, then you go forward 20 days, that valuation period, the block I have on page 12 of the brief, is a period during which all information on the market's been absorbed. That's all we ask. That's all we ask. No more than that. If it's disadvantageous, we'll accept that. Let me go back to another point. We understood from Judge Van Gestel's ruling that he felt we hadn't alleged enough, that for one reason, and we had to also account for breach of fiduciary duty. The complaint had never been amended. He dismissed the case. Leave to amend, although it had been requested, was never granted. We sought reconsideration. We had a one-line order denied. And the cases of this Court are very clear, and of the federal courts, which have the same Rule 15a, that you cannot deny leave to amend without a reason. There was absolutely no reason stated for denying leave to amend. And the amendment would have alleged much more conduct, a whole series of allegations which really directly allege breach of fiduciary duty, and put this in much greater context.
That would, in essence, have been a mirror of the New York complaint?
It had similar elements to the New York complaint.
So in essence, alleging manipulation of the market prior to the announcement.
Correct. And that complaint has been upheld by the court in New York. There was no reason whatsoever. We heard no word why we were not permitted to amend. And I don't know how that can stand. I don't know how that can possibly stand, how you can deny leave to amend, and we represented we could cure the defects, which we didn't really think they were defects, but we could satisfy the Court's concerns. It seems to me that absolutely requires reversal, at least to permit us to have a test of the new complaint, which was not futile. There was no finding of futility, no finding of undue delay, no finding of anything absolutely. And I think at a minimum that we should be permitted to go back and test the allegations of the new complaint based on this Court's view of the law of the Commonwealth.
Thank you, Mr. Schiff.
Thank you very much.